Hall & Wilcox acknowledges the traditional custodians of the lands on which this podcast is recorded. We pay our respects to their elders, past and present, and to all First Nations people joining us today.
Hello and welcome to the latest episode in our Tax Records podcast series. My name is Sarah Shaheen and I'm a lawyer in the tax team here at Hall & Wilcox. I'm delighted to be your host for this episode. I'm joined today by Jacqueline McGrath, who is a partner in our tax team. Today we're discussing tax practitioner board reviews. In particular, we will cover key changes to the TASA and new code obligations, common triggers for a TPB review, and how to prepare for a review or investigation. Jack, at a high level, what are the key changes to the Tax Agent Services Act that tax practitioners need to be aware of, particularly around breach reporting and annual registration?
Sure. The TPB issued a legislative instrument late last year, that essentially codified a code of professional conduct. And that code introduced a number of additional obligations for registered agents. And for context, this came about following a 2019 review into the TASA, which, amongst a lot of other things, recommended that the code be updated, and also more structural changes as to making sure that there was flexibility to update the code on an as-needed basis to address really developing or emerging issues. So as I said, in 2024, a determination was issued that introduced 8 additional code obligations. There was also the breach reporting requirements that were brought in too, which has been quite well publicised. So from 1 July 2024, it's incumbent on agents to report what's called, or what's referred to as, significant breaches of the code to the TPB. And that can involve either reporting the agent's own breach, or if they have reasonable grounds to suspect a breach by another practitioner, they're to report that. There were also changes relating to the whistleblower provisions, or protections, I should say. And then finally, there were amendments made to the TPB's own investigation process, and essentially extending the previous timeframes in which an investigation needed to be finalised. Prior to the changes, there was a 6-month timeframe in which a decision following an investigation had to be made, but now they've extended that to 24 months. And that was really on the back of a view that was formed that many of the investigations really did involve complex matters, so necessarily should be afforded time to properly investigate and issue a decision. So that's been extended to 24 months. So yes, those are the key changes.
Now, you touched on the new code that was introduced. Can you walk us through the 8 new code obligations introduced under the Tax Agent Services Code of Professional Conduct Determination of 2024, and how they impact day-to-day practice for tax agents?
Sure. Working from the top, the first obligation under the determination, the codified determination, is to uphold and promote ethical standards. Now, that's quite broad. The code talks about upholding and promoting the code itself and not engaging in any conduct that could undermine the public trust and confidence in the profession or the tax system more. The TPB's information sheet that sits alongside the new code on this part refers to an expectation that agents provide training and resources on the code, actively manage underperformance, and have recruitment processes that include police checks of the TPB register, and also develop a culture of transparency and accountability. So the information sheet requires tax agents to also maintain records relating to potential breaches of the code, and having processes in place to amend or correct false or misleading statements in documents. And that leads me to the next in the code, which talks about false or misleading statements to the TPB and the ATO. So there are new changes you would have seen about when it's incumbent on the agent to address errors made in reporting on behalf of the client to the ATO. So this extends to statements that the agent ought to know are false. So even if they don't actually know, it covers what a reasonable person ought to have known was a statement made to the ATO or TPB. Or in fact, it's actually broader. It does cover other government agencies. That is a false or misleading statement made within a reasonable period. They have to advise the client that it needs to be corrected, and they have to advise the implications of not taking the action to correct it. So as you can imagine, the implications of not taking the action are things like administrative penalties or shortfall penalties under the Taxing Acts. And following on from that, if after what's referred to as a reasonable period, the client doesn't take the steps to permit the agent to correct the statement, the agent has to withdraw the engagement with the client. It also goes further too, if the statement resulted from recklessness or intentional disregard of the tax law, and you'll know that language is used in the shortfall penalty space. But if the statement resulted from recklessness or intentional disregard and the agent isn't satisfied that the client has taken any action to address it with the ATO, the agent actually has to notify the ATO or the TPB of it. So there are some exceptions to that, one of them being if the agent feels that the reporting could result in unreasonable safety risk to themselves or staff. So the current information note on this obligation goes into some depth about what a tax agent needs to report in terms of the details of the client and of the error. So these are the client's full legal name and other identifying information. They need to actually say that the notification's been made under the determination. They need to confirm that they've told their client that a statement made to the ATO should be corrected, and confirm that they're not satisfied that their advice was actioned. And then finally, they have to provide what's called the reasonable and sufficient information that would assist the ATO in their review of the potentially false or misleading statements. So the examples given in the information sheet are things like pointing them to the particular tax return for the particular year or the BAS for the relevant BAS for a tax period. So the balance of, that's probably really the main one that's been the topic of a lot of sort of discussion. But the balance of the other 8 new requirements include managing conflicts of interests, particularly in government-related work. So this is all about taking reasonable steps to ensure that you identify and document any conflict. It goes further than just identifying and documenting conflicts. There's also obligation to report any conflicts to the agency and taking obviously reasonable steps to mitigate it in the first place. Maintaining confidentiality in dealings with government is another prescribed obligation under the code. Keeping proper records. The code talks about, as a minimum, client records have to be maintained for 5 years. Ensuring services provided by the agent's behalf are competent. Implementing quality management systems. I wanted to talk about this just for a moment. The code talks about making sure that each entity providing tax agent or BAS services on a registered agent's behalf maintains sufficient knowledge and skills, so keeping up with the changes, tax changes, but also, and so those sorts of things are like the CPD, training, appropriate supervision, and documenting and enforcing the policies of a QA system. And finally, the determination requires keeping clients informed about their rights and obligations. So this is about notifying not only about the existence of a TPB register, but also the complaints process, and notifying about any prescribed events such as the suspension or registration.
Now, what is the general process for TPB investigations?
The TPB's website has a good overview of their investigation processes and powers. So they have very broad powers, but breaches of the code or false statements made to the ATO are the main areas of focus. It's usually, but not always, starts from a complaint being lodged. They issue the tax practitioner, the tax agent, with a letter that sets out their inquiry, and then usually within 2 weeks or so, the TPB will give notice whether it's going to escalate to an investigation. There's an information sheet on the TPB's website that goes through the process in more depth and what to expect, and it covers things like an estimate of timeframes for those steps to occur. But generally, after the initial inquiries, they may send the practitioner a please explain letter, so basically setting out what their preliminary inquiries are and giving the practitioner a right to respond and clarify any of those issues, and that should really be answered very promptly and thoroughly. After that response, notice can be issued about the investigation. The investigation itself can involve interviews, further written requests for information or documents. The TPB can go to third parties to get information. The investigation itself can, under the provisions, can extend to up to 24 months. Essentially, they have 24 months to investigate. It used to generally be around 6 months. So then after the investigation, they issue a report or findings. The outcome of the investigation can result in different actions. One can be a sanction, a written caution. It can be a suspension or termination of a registration. It can go to pecuniary penalties too, so the TPB can apply to the court for civil penalties against the individual. And then whatever the outcome of the investigation, it may be reported to the ATO and also the complainant and any other relevant professional body, so places like CPA or CA, if the agent happens to be also registered with those professional bodies.
Now, in your opinion, how can tax agents proactively manage risk associated with a TPB investigation?
Well, I think first, really dedicating time and energy to the initial complaint, or it's referred to as the please explain letter, so answering that very fully and in a timely manner. Identifying if there's anything to voluntarily disclose to as early as you can, to be upfront is best, of course. If it turns into an investigation and there's requests for information issued, again, being vigilant to make sure that you're providing as fulsome and timely responses as you possibly can. It's often really difficult because you're also trying to run a business and meet deadlines and client requirements, that sort of thing, but really dedicating as much as you can to providing very fulsome responses. And finally, I think reaching out for assistance if you need it. There's obviously, as I mentioned before when we were talking about the sort of scope of the TPB's sanctions, there's very serious consequences. So seeking help from specialists can be a good idea. The other thing that I should say too is that the TPB do have webinars available, the information sheets that I've talked about as well. They're really good resources. Oftentimes we tend to overlook these things, but they are a good resource. They also, you might have seen, publish compliance case studies as well. So you can have a look at examples of outcomes of investigations too, because a lot of information in relation to ongoing investigations or finalised investigations are published. So those would be my recommendations.
Thanks everyone for listening today. As always, please get in touch with us if you have any questions. You can find our details on our website, which is hallandwilcox.com.au, or connect with us on LinkedIn. If you enjoyed today's episode, please rate, review, or subscribe to our podcast wherever you get your podcasts. Thank you.
This This podcast is not legal advice and should not be relied upon as such. You should always obtain legal advice about your specific circumstances.